So be it.
Just fear, Your Honor. We're driven
You're
by.
up, Mr. Canigliaro.
Thank you, Your Honor. May it please the court, my name is Matt Canigliaro. I'm with Carlton Fields, and I am here today on behalf of the petitioner in this case, Illinois Union. I'd like to begin just with a bit of housekeeping to inform the court that the trial court in this case has stayed these proceedings entirely pending the result of this case in this court. Also, there is, as was mentioned in the briefing, a federal coverage action that has been filed where I believe all these parties are present. And that too has been stayed pending the result of this proceeding. Now, in this proceeding, we have asked for two forms of relief, a writ of prohibition and a writ of certiorari. I'd like to begin with certiorari. It is the more impactful of the two, and it really gets to the heart of what's going on here. And I think I can sum up the certiorari arguments really in just a single sentence. If this court agrees that the non-joinder statute has been violated, then we have met both of the elements for certiorari, irreparable harm and a departure from the essential requirements of law. Multiple cases have held that a violation of the non-joinder statute amounts to the irreparable harm necessary to qualify for certiorari, and that makes sense. The non-joinder statute is a statutory protection for insurers to keep them out of cases that the legislature has said they should not be in, and that's not something that can be remedied on plenary appeal. And with respect to the departure
Well,
from the
I guess an argument would be made. The reason you have the non-joinder statute is I don't want the insurance company named or otherwise participating in a case where the jury is likely to know that there's coverage. That's not what we have here.
But that's not what we have here, Your Honor. But the purposes behind the non-joinder statute are broader than that one. I certainly agree that's a significant purpose behind the statute, and the case law backs that up. But the statute is more broad. Subsection 4 of the statute explains that a liability insurer can only be brought into pending litigation for two purposes. The first is to enter final judgment, and the second is to enforce a settlement. And all of this is done in the context of what I'll suggest is it's supposed to be essentially a friendly atmosphere. That if coverage is being contested, then you don't bring the liability insurer in. If you're trying to do something other than enter final judgment or enforce a settlement, you can't bring the liability insurer in. There is no dispute that in this case, Illinois Union was not brought into this case to do either of those two things. We were not brought in to enter final
But
judgment.
The Fridman case sort of suggested it's okay to do this, and you're distinguishing that case by saying it's a first party claim.
Which is an important distinction. In
But it's
not
still
only was
something
it
that's brought after the main action.
well, it was also an action against the insurer in the first place. So it's a first party case against the insurer for underinsured motorist or uninsured motorist benefits. And ordinarily, you can bring a bad faith claim in that case. You just abate it. And all the Supreme Court was saying was that we're going to allow that plaintiff who had the UM claim against the carrier is already in the case. We're going to allow at the final judgment stage the plaintiff to be able to amend and add the bad faith claim. What we have here is completely different. This was a personal injury case by an injured person against the alleged tortfeasor. It had nothing to do with insurance, nothing to do with coverage, nothing to do with bad faith. A completely different situation. And so here, there is no dispute that the insurer was not brought in for either of those two purposes under the statute. And for that reason, we have a violation of the non-joinder statute.
Well, let's get the nub of this is your client wants to be able to remove this case.
Yes, Your Honor.
And I know it's not binding, but the 11th Circuit has come out with a number of cases that sort of suggest that there's really no right to removal.
I would suggest that's not the right phrasing, Your Honor. What the 11th Circuit has said was that the right to remove is limited by statute. And the cases that are discussed in the briefing here make the point that one of those limitations is the 1 year period. And that's the period that the plaintiffs here are trying to take advantage of. And we agree that's what underlies this whole situation is this
So
removal
help
interest.
us find a way around it. We've got sort of a different view coming from the first DCA than the fourth has given us on the removal issue in this context. And the first DCA seems to think, in contrast to what the fourth has espoused, that the situation with the removal is not irreparable harm. And I'm sure you've read Rader. Why are they wrong?
Let me offer two related responses to that. First, to get a little bit in front of the answer Your Honor I think is hoping I'll give, and to be direct. Here we have irreparable harm from a violation of the non-joinder statute. So the split between the first and the fourth is not something this court needs to join. We very much advocate which side the court should take if it does join it, but the court doesn't need to join it because we have irreparable harm if there is a violation of the non-joinder statute. The right to remove is important to us. It's what underlies what both sides are doing here. It's our motivation, but it's not necessary for purposes of...
I think this builds on what Judge LaRose was asking you about at the beginning. If the right to remove isn't your irreparable harm, it's the fact that you're named as a defendant and in violation of the non-joinder statute. It's not an immunity. And we know that having to try a case when you don't think you should is not irreparable harm. So help me understand that part of it.
Sure. And I will answer Your Honor's former question as well. There's a general rule that the expenses of litigating are not irreparable harm for purposes of certiorari, and that is the general rule. Things change, though, if you have a statutory right, a statutory protection that has been violated. Here, the statutory right that insurers have, or maybe you frame it as a protection that insurers have, is not to be brought into certain litigation, not to be a part of that litigation. And that's the text of the statute. There are multiple purposes that the statute serves, and one of them here for our purposes is the right not to be brought into an old case, because an old case comes with a problem for purposes of removal. And once you pass the 1-year mark, by statute, we cannot remove to federal court. So it is irreparable harm that, assuming we have a right to remove or would have a right to remove, to be deprived of that does give us irreparable harm, which is why the fourth DCA is correct and the first DCA is incorrect in saying otherwise.
Incorrect, because what I think Judge Thomas said in Rader is if the underlying order is reversed, then the plaintiff will be required to file a separate lawsuit, and then which will provide a new removal deadline. So no irreparable harm. That's how I understood.
That's how I read it as well. But let me suggest where I think the court misunderstood what happens in these situations. This isn't just a sterile right to a venue or a forum. This is something that by statute, within 30 days of being served with the complaint, we have a right to take the case out of a state court forum.
And then to some extent, you've done that by bringing your deck action in the district court, right?
Well, we're trying, but that one has stayed pending this for as you can imagine, for these purposes. I'm sure I
don't want you to use up all your time before I ask you a couple of questions about prohibition. Can I shift your focus for a minute?
Yes, Your Honor.
I think your primary, when you filed your petition, the primary relief you requested was prohibition. I think I got that right.
Yes, we asked for both.
And you pled for certiorari and the alternative. The question that I have for you, and I've struggled with this, getting ready for the argument, if this judge, if the trial court had waited until 15 or maybe 30 days, 30 for sure, and 15 maybe days after the final judgment, allowing an amendment to bring in new parties seems like a real stretch on case jurisdiction or procedural jurisdiction. Am I making sense to you so far for this question?
Yes, Your Honor.
Here, the trial judge enters final judgment pursuant to what seems like a Koblenz agreement with the plaintiff and the defense then existing. And the next day, without a motion or anything else, essentially propagates a situation where the plaintiffs now amend their complaint without having sought leave and bring in new parties. And that does seem like an extraordinary move to exercise jurisdiction over parties who were never there at the beginning. But what I wasn't able to find, and I did find plenty of, this is a completely independent action. This isn't it's unrelated to the tort. We've talked a little bit about that already. But what's your best case? Or I know that case jurisdiction will support prohibition, procedural jurisdiction, acting beyond the court's procedural jurisdiction is sufficient for prohibition. I believe you told us that in your brief. But what's your best case for the trial judge lacking jurisdiction within the rehearing period to allow an amendment, putting aside the propriety of doing it without a motion for leave, substantively, to allow that amendment to bring in parties who were never there?
I'm going to do my best here.
And a new cause of action. And if we had that case, I think this would be a completely different conversation, but I couldn't find it.
And nor could we. And really, this is why I started with certiorari, because I think what we need to win on certiorari is for this court to look to existing case law with principles that are already set forth in those cases. On prohibition, it's a little different. We're working really from first principles. The Supreme Court's decision in Lovett, it's a very old decision, but makes the very correct and still very accurate point about how the court's jurisdiction doesn't just exist in the air, it has to be called. And it's called by the pleadings. And the Fifth DCA's decision in the Fine case has some wonderful language for our purposes that says the court can only act within the scope of the pleadings. So here we had a personal injury case, an injured person sues an alleged tortfeasor. The court's action was limited to acting within the scope of those pleadings. In this case, there was never a motion for leave to amend. The final judgment in its own text authorizes the filing of an amended complaint by the plaintiff to bring a completely different case against non-parties, including us. And so there is a lack of jurisdiction here, if only because it's completely outside the original case. There was never a motion for leave to amend, not before or after the judgment. The judgment just out of nowhere springs into life and the plaintiff can sue someone else on something completely different, but go ahead and do it here in our case. And we all know why this happened. It happened as part of a settlement. It's Koblenz. At the end of the day, the bottom line for our purposes is that Koblenz is inconsistent with being able to do what's happened here, which is bringing the liability insurer into the underlying case. And that's, unfortunately, there's not a case yet on point. Perhaps this will become the case. But that's really where we are, is relying on first principles for jurisdiction here.
Under prohibition. And to sum up, because I want to make sure I understand your certiorari argument, it is that one or the other or both of being unable to remove and being sued in violation of the non-joinder statute under the existing case law gets you one way or the other to irreparable harm.
Yes, Your Honor. And the violation of the statute here is that we've been brought in for neither purposes of entering final judgment or for enforcing a settlement. The Fourth DCA in the Beasley case said, if you want to litigate coverage, you must bring a separate action. And they were correct. And if I could reserve the balance for rebuttal, I would appreciate it.
Very good. Thank you, Mr. Conigliaro.
Good afternoon.
Mr. Walker, you're up.
Thank you, Your Honor. Good morning. May it please the court. I'm Bill Walker. I represent the respondents in this matter. And what I'd like to address initially is Judge LaBritte's point about prohibition. First, this court entered an order asking the parties to proceed on the basis of certiorari and not prohibition. That was a threshold issue that the court determined. But even on the issue of prohibition, what we would say is there is no case finding that there's no jurisdiction for the trial court to do what it did. because the trial court has, in fact, jurisdiction to grant the amendment. Number one, it reserved the right to do so in the judgment itself, thus obviating the need for a
Well, what
motion.
about, I mean, first of all, with respect to the order, if I'm not mistaken, it suggested that certiorari was, among other things, how the case would be set up. I think it left to the panel the decision as to what the ultimate relief could be, and I think that's consistent with the appellate rules as well. But putting that aside, I am troubled by a court entering final judgment in an automobile accident tort liability case after a couple of years of litigation and co-balancing and whatever, and without any apparent prompting, maybe the trial judge viewed the co-balance agreement and the underlying settlement and stipulation as being enforcement of a settlement. That might be your best case. But I'm troubled by how the trial court can, in one fell swoop, enter a final judgment that, without having been asked in any obvious way to grant this relief, allows the plaintiff to amend and bring a whole new case that is unrelated to the tort that was litigated in the original action against all new parties, and call that within the court's, the scope of the pleadings or the other language of legal standard that's been thrown around about what the court has in the way of procedural jurisdiction. Help me out with that.
Well, Your Honor, first of all, I'd say that the Florida Supreme Court in both Pereira and Friedman say that this is an appropriate procedure, that adding parties to the existing case via consent judgment.
Well, that's the existing case is sort of where this starts to fall apart, because the trial judge has entered final judgment. It's not an interlocutory order that says, okay, the claims that were against these defendants who've been abated can now come alive. It is a whole new case.
But even in this court's Schmidt decision, identified, remember that the court retains jurisdiction broadly within 15 days of entering final judgment, number one. And number two, to the extent that it reserves jurisdiction. We know that the trial court has subject matter jurisdiction over the parties. We know that it has personal jurisdiction over the parties. That hasn't been contested. So in effect...
Well, but I'm sorry, I don't mean to cut you off so quickly, but the trial court had no jurisdiction over the extra contractual claim. And it had no jurisdiction over Illinois Union and the two brokers because they weren't there and that claim hadn't been pled. So it seems to me to be a little bit of a stretch to say, well, the trial court always had jurisdiction of this because it was somewhere in the neighborhood of what might happen in the ultimate resolution of this claim. But the parties weren't there and the claims weren't there at the time that the trial court entered the final judgment. And, you may have the better half of it just because there, as your opponent has conceded, this would be, we're going where no man has gone before. But I have trouble categorizing the claims that were pled in the amendment against the parties that were added by the amendment as part of the original case, because it wasn't.
Well, Judge Levert, I think that's fair. If you're going to look at this as what's part of the original tort case, you're right. These claims are not part of the original tort case. I mean, there's no question about that.
The question is what jurisdiction, you said you started out by saying the court had personal jurisdiction, which it did over the defendant and the plaintiffs, but though it didn't have any personal jurisdiction over these parties because they'd never been served or added or named or anything.
Right.
And it didn't have subject matter jurisdiction over the contract claims because they'd never been pled.
I disagree, Your Honor, and let me explain why, if I may. All right. The concepts of personal and subject matter jurisdiction are we take broadly. The court always had personal jurisdiction and subject matter jurisdiction over Illinois Union. If we had filed a separate lawsuit, there'd be no contest that it lacked personal or subject matter jurisdiction. What it seems the court is struggling with is, okay, where this trial court has broad jurisdiction over these parties, how does it acquire that in the context of this existing case. And that's where we drill down to the issue of case jurisdiction. And what I would submit to the court is it has the case jurisdiction to permit amendment. There is not a limitation on that case jurisdiction in the case law. It allowed that amendment. The amendment was filed timely, and then it acquired personal jurisdiction once the new defendants were served, just like it would. This is no different from the addition of any other potential defendant. If the court's troubled by the fact that the cause of action is different, that happens frequently when defendants are added to existing lawsuits. The question really is this, and I get what you're saying, Judge. It seems uncomfortable, but is it, improper in terms of being in violation of the law somehow? And it is not. And we've cited to the court to numerous cases where this procedure was applied, including those cases in which the Florida Supreme Court acknowledges.
So a question I might have would be this: can the trial court retain jurisdiction if it does not already have?
Well, that's an interesting question, Judge Case. What I would say to you is, even if it could not, because the amendments were filed within the 15 days, within the 15 days following entry of judgment, it did not need to retain jurisdiction. It did not lack jurisdiction.
So if the court had allowed this amendment before the entry of the judgment, what's the outcome?
The outcome is that we're still here because Illinois Union would be arguing that it still violates its right to remove. I think we've expressed it in the briefing that I think this jurisdiction argument is a bit of a red herring because there is no law against it, and that we'll still be here regardless. The other aspect of it, Your Honor, is simply this: these are not unrelated claims. I realize these are not tort claims, but this is a breach of contract claim related to the failure to defend the tort claim. It is a declaratory judgment claim on the basis to determine coverage that should have been provided for the tort claim.
Well, look, we've got case law all over the place.
I
very clearly says these are two different, they're altogether different causes of action.
Well,
completely separate. I mean, I'm just looking at merchants and businessmen. One is a tort action against the insured. The other is a coverage action and they're essentially unrelated and constitute separate and distinct legal actions.
They are separate and distinct legal actions. I don't dispute that at all. But to say that
the fact that any given court may have jurisdiction of any given citizen wandering around in the state, isn't there a triggering event like being named as a party defendant and being sued that would activate that jurisdiction, as opposed to it just exists because it wouldn't survive a challenge?
They were named as a party defendant, they were served, and they were sued. That's what.
Well, that was after the final judgment was entered.
Yes, but the narrow issue is simply whether a court can permit amendment after final judgment. Everything else has been satisfied: personal jurisdiction and subject matter. So really the very, very narrow issue of jurisdiction, Your Honor, is whether a court has authority to grant amendment to the complaint after final judgment, and irrespective of the preservation language, as I mentioned to Judge Case, in the judgment itself, within 15 days of entry of that judgment. And the answer is, it does. There's simply no limitation on its jurisdiction in that regard in statute or in case law.
So question I have at this time is that why isn't the Travelers versus Sidman from the second controlling or on point?
I'm sorry, Judge Case, I didn't hear the name of the case that you cited to.
Travelers versus Sidman. Second?
Well, I think we distinguished the Sidman case in our briefing, but the short answer is in Sidman, the 15 days had expired. And so the court entered judgment, there was no preservation, 15 days expired, and then it granted amendment. And the court held, nope, if you don't preserve jurisdiction and you don't get it done within that 15 days, you lose it. That's when you lose case jurisdiction. And we don't have that situation here because the amended complaints were filed within the 15 days and the court reserved jurisdiction. May I proceed on the other arguments?
Yes, please.
Thank you. With respect to removal being irreparable injury, we not only have the fifth DCA saying we don't accept it, and the first DCA saying we don't accept, that being irreparable injury subject to certiorari, but we have the federal courts themselves indicating that removal is discretionary. It is not a right. What we cited to the 11th Circuit Vachon case in that regard, as well as the trial court's case. Forgive me. In Brown, in which which both courts say the plaintiff has the right to choose venue, and the fact, even if that venue eliminates the ability of the defendant to remove. Moreover, the defendants Illinois Union here is treating, removal as if it would be certain, but for, their joinder to this case, when in fact, in order to remove, they would have to prove consent of the other defendants. They've not established it. They would also have to establish that Coast to Coast Specialty Insurance was fraudulently joined. They have not established that, nor were they. And more importantly, in both Harvey and Vachon, the carrier attempted removal and was subject to remand. And that's what established that there was an inability to remove it. Illinois Union has not established that. And they argue, oh, we didn't have to because we knew the court would remand us. But there are certainly trial court level, district court level cases in which removal has been accepted, in which bad faith claims have been severed. The reality here is Illinois Union will be in state court because there is an appropriate declaratory judgment claim against them, and there's an appropriate breach of contract claim against them, which are first party claims, not subject to the non-jointer statute. And so the only thing that they're complaining about is the existence of an abated bad faith claim. And that doesn't change the outcome on removal, and it doesn't change the outcome, I would argue, on non-jointer because they're properly joined to first party claims. And unless there are any other questions by the panel, we would stand in our briefing.
Very good. Thank you, sir.
Thank you, Your Honor.
I want to,
Mr. Canigliaro,
Your Honor, if I could jump, I'm sorry.
4 minutes to rebuttal.
Thank you. If I could jump in right with counsel's last point that some aspect of this complaint is not subject to the non-joinder statute. That is simply not the case. Whether you dress your claim up as a deck action or anything else, these claims are all subject to the non-joinder statute. I'll go back to the 4th DCA's decision in the Beasley case, where their exact words were, a separate action must be commenced against Beasley to litigate the issue of coverage. And that's because there are only two purposes that you can join a liability insurer into a pending action. That's the language of subsection 4 of the statute. And those two purposes, neither of them is met here. Counsel hasn't suggested that they were. Counsel is suggesting that there's some claim that gets around that, and that's just utterly inconsistent with what the statute says. With respect to the non-joinder statute, if the court agrees there, then the analysis really becomes complete. We have irreparable harm because the insurer is being joined in something it's not supposed to be joined to. And I'll add, this actually gets to both the substance of...
because I don't think we touched on this much. I think one of the arguments that your friend on the other side is making is that because I think it's all, but it might be most, of the claims that the plaintiffs have now brought, they're bringing in their capacity as the assignee of the insured. And So if I understand their argument correctly, that takes you out of the non-joinder statute for the purposes of all of those claims that are brought in that capacity. And I believe, like I said, that it was most, if not all, I think it was most, maybe one or two didn't meet that criteria. What do you say about that?
That they are incorrect. If that is their point, they are incorrect.
The assignment doesn't do what the assignment does in every other insurance context?
No, they have an assignment, but that doesn't change that the non-joinder statute limits when a liability insurer can be brought in. The Geico versus Harvey case out of the 4th DCA, it was the insured who brought the insurer in. It wasn't the plaintiff to the relationship. It was the insured who brought the insurer in. And the court still looked at the non-joinder statute and said you can only bring
that takes us then to Rader, if we follow.
Sure. Okay. And, well, there's the departure side and the irreparable harm side. On the Rader was really dealing with irreparable harm, and I'll suggest that part of why Rader misunderstood things is to not appreciate that when it is a right. The right to remove is exactly that, a right to remove. And when you cannot remove and you're forced to litigate in state court, a lot of things happen over the course of that litigation. To go through an appeal, you had a right not to do any of that in that forum. And with due respect to the 1st DCA, I think the 1st DCA simply misunderstood that all of that litigation, whether it's going through depositions, going through hearings, making statements and stipulations, or whatever else can happen over the course of a case, none of that should be happening in state court. The right is to remove and be in federal court. So we have both irreparable harm if the right is infringed, and we have a departure because the non-joinder statute was violated. And at the end of the day, it is violated by these claims going forward here because a liability insurer has been brought into this case when it's not for either of the purposes that are authorized in subsection 4. Okay. We ask the court to enter a writ of prohibition or a writ of certiorari. We do emphasize that this issue is important not just to the parties here, but on a larger scale, and we ask that the court speak to the issues.
Thank you, Mr. Conigliaro. Thank you both. That concludes our docket. You can push the button